Just move. Don't be asking any. Just move. They told you to move. Just move. I don't know why you have to argue with them. And yeah, no. I saw it. Feaster was gone. It's her. Like if my mom died, my dad already did.
Mr.
You
Scott.
know what I'm saying? Like my sister
Scott.
died 2 years ago. Like,
Mr. Scott,
yes, sir.
I have heard you. I have made my ruling. I'm done. Court calls the case of the people versus Samantha Classic.
Ready, Your Honor.
Ashley, people.
Good morning, Your Honor. Joseph Paul Pinkford on behalf of Ms. Classic, who now stands to my right. Ms. Classic, if you could state your name for the record, please.
Samantha Nicole Classic.
Thank you, Your Honor. We're here for PCC today. We were last here 1 week ago. I appreciate the short adjournment and the purpose behind that. We are still awaiting the discovery, the call for service and dispatch. I'm sure we're going to get that squared away soon enough. We would ask for an adjournment to allow discovery to get completed.
Okay.
And
I'll adjourn it to the 20th, 2025, 9 a.m. Go ahead.
Your Honor, if we may also address bond at
Briefly.
very briefly, Your Honor. Ms. Classic is in here for a dirty marijuana test. She was forthcoming the last time we were here. She's attended AA or NA every time it's been offered to her in the jail. The point has more than well enough sunk in. She lives at home with her parents, and there will be no driving. We would ask that the court consider, and Your Honor, although it hadn't arrived as of yesterday, we have approval and a medical marijuana card we believe is in the mail. We understand that doesn't shore up the gap in time, but we would ask Your Honor to consider after 1 week a reduction in her bond that would allow her to be supervised in the public. She will comply with whatever testing would make the court feel comfortable.
Response from the people.
Your Honor, I would leave it in the discretion of the court. I think the court already has all the information from the people. Reference our concerns about the defendant having tested positive for several substances, going to inpatient treatment and coming out and continuing to test positive for marijuana. I will leave it at that.
Yeah. And given the nature of the charge, that is the other thing that
I understand that's playing into Your Honor's decision.
is she working?
No, sir.
Not this, Your Honor, with treatment. And I believe so she got out of inpatient almost immediately before the last hearing, about a week, I think, prior to the last hearing. And the day that she went in was the day that she was going to go orient with outpatient. So treatment is her primary focus right now. If Your Honor wanted employment, I'm sure Ms. Clark.
No, I just wanted to know what she does during the day.
During the day, she'll be focused on her continuing treatment, Your Honor. I think that's where she believes, Your Honor believes, I and her parents believe her time is best spent.
Set this on the 20th. I'll reinstate the defendant's previous bond
Thank you, Judge.
with its conditions.
Absolutely.
Thank you.
Thank you, Your Honor. All right.
Space.
Just move. Don't be asking any. Just move. They told you to move. Just move. I don't know why you have to argue with them. And yeah, no. I saw it. Feaster was gone. It's her. Folks, is that good enough for you guys?
Will that work for you? Court does call the cases of the people of the state of Michigan versus Gregory Callahan, Keith Finney, and Siobhan Benson.
Good morning, Your Honor. Advisor appearing on behalf of the people.
And good morning again, Your Honor. Rita Young, P44626, appearing on behalf of Mr. Callahan, who is present, and I'm appearing on both cases.
Better state your name.
Gregory Callahan.
I thought they were. Two that were out.
They're bringing it to, yeah.
Oh, they're clearing space.
Yeah.
And instances. City. All right. Barnwell, could you state your appearance?
Yes, good morning, Wendy Barnwell, P42505, on behalf of Mr. Keith Finley.
Ready, Judge. Torsia Feaster, Assistant Public Defender, on behalf of Ms. Vincent, who's on Zoom. Ms. Vincent, please state your name for the record.
I'm Mama Truth, Siobhan Benson.
Thank you. All right, your name, sir? Thank you. All right, we had a bench conference, I guess the record to reflect, we had a bench conference in this case regarding the setting of this matter. And after going through everybody's calendars, and I will tell you, I think there is some conspiracy because of all the dates you could pick, yeah. So
Apologies.
no,
Sorry.
don't even apologize because all of you were in it. So I will say discovery will be complete by that time. The people would have their witnesses available April 16th.
Yes, sir.
So I will set preliminary examination in this matter after going through everybody's calendars for April 16th, 2025, 9 a.m. That is before me.
That is correct, Judge. Thank you so much.
Thank you very much, Your Honor.
I'm gonna say you're welcome.
Thank you for accommodating the schedule.
Yes.
All right, bond will continue as not.
Thank you, Judge.
Hey, Brianna.
Thank you, Ms. Vincent. Court does call the case of the people versus Daniel Greenwood.
And then on behalf of the people,
Good morning, Your Honor. Good to see you. As always, Robert Ellman with and on behalf of Mr. Greenwood. Mr. Greenwood, can you please state your name for the record?
Daniel Lowell Greenwood.
We're still waiting on a competency.
That's my understanding, Your Honor. I have just been appointed to this matter just this week, but after speaking with Ms. Zenda, I do believe there is some kind of holdup with the competency evaluation.
Yeah, I have a January 7th letter that they're looking at for records. That's the last communication I have.
That's what the people have, Your Honor.
All right.
May I speak, Your Honor? No?
Sure. Go for it.
I am a CIA agent on record with the United States of America, and I noticed some flaws in the paperwork. Where it says arrest date and time, it says at 3 a.m., but where it says time booked, it says midnight. How was I arrested after I was booked? That's a motion for dismissal. That's all I have to say, Your Honor. And I will be pushing for wrongful incarceration.
Pardon?
I will be pushing for wrongful incarceration of a federal agent.
Okay.
Your Honor, Mr. Greenwood did discuss these things with me. I did tell him that we needed to wait for the results of the competency exam before we could move forward on any of those issues. However, I am.
And your legal assessment of that is correct.
Thank you, Your Honor.
You're welcome.
And like I said, I was just appointed. I guess to me, as I could see in the register of actions, it looks like the competency exam was ordered back in potentially July.
It was ordered a while back, and there's issue with some records. So what I'm going to suggest is that contact the forensic center and try to see if they need a new order. I don't think they do, given the January 7th letter that was sent. I think they just are waiting on something before they can complete the evaluation. So what I will do is I'll adjourn this to March 27th. If we get a report before then, we can of course move up.
Thank you, Your Honor.
Competency hearing March 27th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you, Your Honor. Have a good day, Mr. Greenwood. I'll talk to you soon. Have a great day, Your Honor.
I will, thank you. Fourth calls case, People versus Fabian Herrera.
Joseph and Gomez, people.
Good morning, Your Honor. James Fifelski appearing on behalf of Mr. Herrera, who is a. You state your name for the judge, please.
Yes, Your Honor. My name is Fabian David Herrera.
Thank you.
Sir. Your Honor, I'm asking for a 2-week adjournment. There's some surveillance videos that we'd like to get, as well as body cam. And then I'd like to address bond as well, please.
February 20th, 2025, 9 a.m. Esteban.
Your Honor, it's my understanding you had a personal bond. There was some sort of bond violation, but I have not received any paperwork on that. So I'm not sure where that stands, but I would be asking for a bond to be reinstated. Yeah, thanks.
Well, why would I do that?
I'm not sure. Yeah, I was under the impression that is a personal $5,000 bond. And a few days ago, my client was at the hospital and got arrested for some reason. He wasn't sure why, but then he ended up.
Like no use of alcohol, maybe?
That could be.
That could be.
That could be. So
maybe you want to see the report before you make the request to have his bond changed. But at this time, I'll deny your request to change his bond. Bond will continue. Thank you.
Okay. Thank you, Judge. Your Honor, briefly, could he be placed on a tether and released on a personal bond? We've got several compelling reasons, I believe.
So I just what?
You said no bond. I just wanted to make a brief request for the record.
Okay, and for the record, that is also denied.
All right.
Thank
you, Your Honor. Have a good day. Got your
All right. Court does call the case of the People versus Barrage. Ante Scott.
Assistant Public Defender Ashley Bashir here with and on behalf of Mr. Barrage Ante Scott.
Barrage Scott.
All right, what are we doing?
We are seeking to adjourn on both matters. And also we would like to address bond.
Purpose of the adjournment? I don't have the green form.
Our understanding is that there is currently no misdemeanor offer in this case, and we are seeking to advise our client on next steps. I said no, there's no misdemeanor offer. Yes, that's what I said. Sorry. Yeah. So there is, just to reiterate, there's no misdemeanor offer in this case, and so we're seeking to counsel the client on that.
February 20th, 2025. Esteban.
Yes. As to bond, Mr. Ante Scott has been in custody for 16 days. He does have a place to return to. It appears that this is the only matter holding him. He's also willing to go on a GPS tether in order to comply with conditions. He's appeared for, there's been one hearing combined previous to this hearing for both cases, and he has appeared at that hearing. When he was out of custody at the time. So we would argue that he is not a flight risk and not a danger to the community, and we'd request a PR bond.
Response from the people.
I think you're aware of Scott's history of his was. That's a criminal history that goes back several decades. multiple felony convictions, misdemeanor convictions. Whether or not you have a history here off the top of the head. In his history, I certainly have concerns. Like,
Well, and I don't know whether or not this defendant can, well, I have grave doubts as to whether or not he would be able to comply with any bond conditions that the court gives him. I've been through this time and time again with him, giving him a chance, letting him out. Next thing I know, he's violated the bond conditions. He's back in, pleads with me. I would let him go. We put more conditions on him, trying to let him out, and he just doesn't comply. And that's the concern for the court. I think ultimately we would find a flight risk like he's going to flee the jurisdiction, I doubt it. Flight risk that he may not come back and we got to go get him, real likely. So,
All right. Thank you, Your Honor.
bond will be, I'm denying the motion. Bond will continue. Thank you.
Can I say something? Sorry, please, because I don't ever get to talk to you all the time. But I was just gonna say, like, it's kind of crazy because like the trespassing that I do have today, I do have a PR bond.
Mr. Oh, sorry, let's go.
I do have a PR bond on that, and I am released on tether and Romulus, that I have a PR bond on that case. And they have released me the day on the 27th. I had a writ that I had to go to Romulus for another case, but I have a PR bond on that, release the tether. I would really ask for this chance for opportunity to be free one more time, because like I did come to court and I will come to court. It's not like I won't come to court. And I want to have a chance to be with my family. My mom got cancer. Like, I know you haven't heard none. I was supposed to get my tooth fixed on the 30th, like we talked about. I couldn't get my tooth fixed because I'm in here. I had a seizure when I first came in here, and didn't nobody, take care of me like they supposed to. I would really like an opportunity to be free and really have this PR bond. I will come to court and I won't violate. I did come to court. I did make it to all my court dates. You know what I'm saying? I'm not a flight risk, and I would like an opportunity to be free, Your Honor. And if it's anything that you can put conditions on, I will follow them. I just did a year. I don't want to do it again. I changed my life. My birthday was January 20th. I just turned 37. So I know what I'm looking at. I know what everybody has looked at me and want me to change. It's time for me to change my life. It's not a matter of playing with nobody's life and playing with the judges or playing with the prosecutors or none of that. I would like an opportunity to show you that I can change my life without being incarcerated, because it's not helping me.
Mr.
I would like.
Mr. Scott, how many times, forget all the other judges because they've got their own thing. Have you and I been through the same thing?
Yes, Your Honor, but
how many times do you think it is?
No, what I'm actually saying is, like, this could be an opportunity for you to see me to do better in life instead of doing what I
Like
used to
the
do.
last three times.
I changed.
Last three times were an opportunity for me to see that too.
No, what I'm saying is I changed my life since then. I had changed my birthday's January 20th, sir. And I had changed my life since then. I don't want to keep doing
Raj, I'll take a look at it for the next time you get here, but I'm just keeping what I said.
I mean,
if it's bond reductions denied.
And
if you want to keep talking, I may not consider it the next time you get here.
I understand. I was just trying to
Mr. Scott, we can address it later.
say something. That's all. I mean, I know you're not gonna change your mind, but it was just, I had to say it on record. And like I said, this is not a place that I would want to be on. I changed my life since then. I don't want to keep coming here. I don't want to see y'all like this. Definitely don't want to see nobody to, to judge me, because people are judging me about my past record, and it's not fair. I can't pay bond because I don't have the money, and like I'm on disability. That's the only money I get. When me being in here, they can cut my Social Security off, and I have to wait another year to get it on. You know what I'm saying? I'm not gonna be able to. My grandma's not gonna put no food in here for me. Ain't no way I can get anything that I need. No calls or see how my family doing. My mom, like I said, my mom got breast cancer, and she just lost all her hair. She got that cancer where you lose all your hair. I don't want to have nobody die in here, and I cannot talk to him no more. That's all I'm saying. Like if my mom dies, my dad already dead.
Mr.
You
Scott.
know what I'm saying? Like my
Mr.
sister
Scott.
died 2 years ago. Like,
Mr. Scott,
yes, sir.
I have heard you. I have made my ruling. I'm done.
All right, that's fine. I tried.
Court calls the case, People versus Christopher Miller.
Good afternoon, Your Honor. On behalf of Christopher Miller. State your name.
Christopher Grant Miller Jr., sir.
All right. Your Honor, a few things to address here. One of them, the probable cause conference, I'll ask you.
Pardon?
Few things to deal with. First is the probable cause conference. Ultimately, I'll be asking for an adjournment on that. The last time we were here, I was looking to obtain video of the situation. I haven't received any video to my knowledge, and I just communicated to the prosecutor. He's going to be sending another request. I would like to obtain that prior to making a direction in this case. So I filled out a wonderful green form to accommodate a seeking an adjournment. The other thing to potentially address is there's a bond violation report that I certainly would love to address. He has, the last time we were here, we had also talked about him getting employment. To my knowledge, he has a job, and to my knowledge, he also is getting a paycheck on Thursday. He reports to me that he would, if he were to test, and I had that conversation with him just now, that he would pass any alcohol or drug test. He would have the funds to start testing today. And if he were to test today, it would be no violation of any sort. So with that, I'd like to get him to community corrections within 24 hours to make that initial test. And I would like him
He's missed 4 in a row.
I understand that, but he's had some financial difficulties.
Yes, sir. I didn't have the money the whole time, sir, because I basically, once I start the job, I don't get paid until 3 weeks until after the job, or not until after the job, but after the start date, sir.
Now, the focus shifts from the original criminal allegations to something that often lands defendants back in custody: compliance with bond conditions. Once a judge releases someone on bond with requirements like drug testing or reporting to community corrections, those conditions become court orders, not suggestions. The defense is arguing that this was simply a financial problem and that the defendant now has a job and can finally afford the testing fees. But from the court's perspective, the bigger issue isn't just the missed tests. It's the complete lack of communication after promising to comply. Judges often view silence as a sign that a defendant cannot be relied upon to follow future court orders. If you were the judge, would you see this as an honest financial setback or as someone failing to take the court's conditions seriously enough?
So
First check.
you read the report, right?
Yes, Your Honor.
He goes over, he says he doesn't have that, but then says that he would borrow the money from his aunt in return.
I tried, and she didn't have it,
And
sir.
he didn't return. And he didn't submit to any tests, and he didn't call them back either.
Sir, I was actually trying to stay in contact with my attorney and actually have a bunch of phone calls, which my fiance does have on her right now. That
Hold on,
I didn't get any return.
sir. You didn't go. Why didn't you call him back?
He's talking about community corrections.
Because I was trying to get a hold of my attorney to figure out if I can get a hold of you, trying to see if I couldn't get the fines waived, sir. That's all. I was trying to see if I couldn't. I don't have no problem dropping. I just didn't have the money at the time, sir. So I was trying to get a hold of my attorney because I was trying to get him addressed where, like, to get a hold of you to see if possibly I could get those fees waived until I got my paycheck. And I'd have paid it all at once. That's all, sir. I promise I wasn't trying to evade or anything like that. That's why I was trying to stay in contact with my attorney, but he was busy this whole time pretty much.
Your Honor, last time we were here, I also addressed that he had walked himself in on this case. He had also walked in, there was a child support order. He's working to try and get in a direction to where he can start taking care of this case and a previous child support warrant. So the fact that he is employed and has a job, I'm asking that he can continue in that job and not.
Right, but the problem, the difficulty I'm having here is I amend the community corrections order. I release him on the 23rd, I think it was.
Yes, sir.
He's supposed to test, told him he was supposed to test, and now I'm here. That was on January, when was it? No, that was, yeah, January 23rd. Now here, first part of September, and I don't have a test at all. I don't have not one.
I sorry, sir, and I promise it won't happen again. I really would appreciate this one more chance so I can go do this because now I finally have the fee. Now I have the money for it. That's all. That's all. I'm just asking for one more shot, sir. And I will not let you down.
I don't understand why you didn't call them back. You went in, said you didn't have it.
Yeah, because I asked her, but prior to that, I had asked her if any way I can get these fees waived. And she said, no, I had to pay this every time I drop. So that's why, sir. I tried to get it that day. I couldn't get it. So then after that, literally that same day, I tried to contact my attorney to see if there was anything we could do before this date even happened so I can get back on the track to drop again. That's all, sir.
Having a hard time believing.
Your Honor, I mean, it's strictly a financial issue.
I get that part of the issue. What I don't get is why he didn't call community corrections back after he said he was going to borrow the money. Then community corrections gets no call.
You're right, sir. And I do apologize. You're right.
No call whatsoever.
You're 100% right, sir. That's my fault. And I do apologize. That'll never happen again.
I think it would be nice to get a baseline to find out if he's telling the truth on whether or not he, how he would test.
No, I get it, but I'm now 2 weeks down the road without a test. And I let him out on his promise he was going to go test.
Perhaps it would be appropriate that
And
during it 1 week, have him test within 24 hours and come back and see where things are.
What would be appropriate is he's violated a court order and he should be remanded. That's what's appropriate.
I'd like to fight hard for this gentleman right here who is employed. He's getting a paycheck on Thursday. He's going to have the financial means to continue to test pursuant to the court order 2 times a week.
You have the money to test today?
Yes, sir, I do. Yes, sir, I do.
I ought to lock you up.
And I wouldn't blame you, sir, because I did mess up. And I do apologize. I was really just trying to get a hold of my attorney. And it does sound dumb. And I understand, sir.
I can understand you getting a hold of your attorney. I get that. But you didn't even pay the courtesy to the people at community corrections to call them back.
Yes, sir. And I do understand now. I would promise you, if you give me this one last shot, I would not break it. And
I'm going to tell you what. I'm going to give it to you. I'm going to do a new community corrections order, standard supervision. You are to test today.
Yes, sir.
If a dirty test come back, you miss a test or anything along those lines, I don't want to hear anything. You're going.
Absolutely, sir. I promise I won't give you any excuse. I won. I got a lot of people depending on.
It'll be adjourned to February 13th, 2025, 9 a.m. 1 week. And you better hope he's clean.
I will be, sir.
You know what? You need to be quiet.
Thank you, Your Honor. I have this form.
And thank that man next to you because, quite frankly, my customary practice would be to send you.
So, and regarding the, obviously, I really do hope for a quick turnaround on the video, but I'm not sure it may.
Well, we may have to adjourn it out, but you've got bigger problems because I want to make sure I get a test. You are to go over there right now.
Thank you.
See? Like that cartoon, and then his heart grew 3 times too big.
This was one of those rare moments where a defendant came within inches of being remanded into custody, but managed to earn one final opportunity. The judge made it clear that, based on the bond violation, the standard response could have been immediate detention. Instead, the court exercised its discretion and gave the defendant another chance under a new community corrections order, with an immediate drug test and a very direct warning that any future violation, whether the positive test, a missed test, or another failure to comply, will almost certainly end that opportunity. The judge's decision wasn't based solely on sympathy. It was influenced by the defense highlighting the defendant's new employment and willingness to get back into compliance. Whether that trust is rewarded now depends entirely on the defendant's actions, not his promises. Do you think the judge made the right call by extending one last chance? Or should the bond violation have resulted in immediate jail time? Let us know your thoughts in the comments. And if you enjoy real courtroom moments where every decision carries serious consequences, don't forget to like this video, subscribe to the channel, and turn on notifications so you never miss our next courtroom breakdown.